They did some work on House Bill 2013 on unlawful possession of a firearm. So it's now illegal for a felon to possess ammunition as well as the firearm.
At a recent local Public Safety Coordinating Council meeting, we heard from District Attorney Beth Heckert. She summarized several recent modifications to both major and minor laws in Oregon. One of those modifications was regarding HB 2013, which prevents certain justice-involved individuals from owning ammunition. Keep watching to hear the summary and potential impacts of the changes.
So although we're in the midst of the 2020 session, this is the legislation from 19. They did some work on House Bill 2013 on unlawful possession of a firearm. So it's now illegal for a felon to possess ammunition as well as the firearm. And if you have a restraining order or you're convicted of certain crimes, domestic violence crimes mostly, then you're now going to have to dispossess yourself of firearms and ammunition. So the court would inform the person if they get a restraining order or they get a conviction, for example, for assault in the 4th degree and domestic violence, then they are going to be told by the court that they have 24 hours to dispossess themselves of their firearms and their ammunition. The way you can dispossess yourself of those things is you can turn them into law enforcement for just safekeeping, holding, until it no longer applies to you. So someone who only has maybe 1 or 2 guns, maybe that's not as big of an issue for like the Sheriff's Department or Medford Police Department. But we have people, who might own 20 guns or more, or large guns, or a real variety of things. So I don't know if that's really posed an issue yet, Sheriff. Have you seen very many people do this?
No, we really encourage them to find a family member that can take them. We don't want to be the de facto gun storage. There's some liability. Some of them are valuable, and if they're not in the same exact condition that they thought they were when they brought them in, do we get sued or whatever, or have to absorb those costs? So we don't encourage them to do that, but we won't turn them away if that's their only option.
And so you can also give them to a third party, a family member, or some other person who doesn't reside with you. They have to go through a background check to make sure they're allowed to take them from you, because maybe they have some disqualifying conviction or mental commitment or something that would make them not able to take them from you. You can take them to a gun dealer. I'm assuming the gun dealers are probably charging people to store them. I haven't really heard from anybody on kind of how that part is working. But so if you don't do these things, then the district attorney's office can file a contempt charge against the person for failing to abide by this court order that they were told to dispossess themselves. So let's say, for example, you don't own any firearms. There's a form that you fill out and you just check a box that says, I don't own any firearms. You turn that into the court, you provide that to the district attorney, and that satisfies this statutory requirement that you've complied with that statute. So we've seen a few people using that. You can also tell the court how you disposed of your firearms. So you can say, I provided them to the sheriff's office or to Medford Police Department, and here's the receipt. And so there's some documentation that goes along with that. You provide that to the district attorney's office. We get that in the court, and there's no contempt filed then. There's also a box you can check that just says, I invoke my rights and I'm not going to answer these questions. So if someone checks that box, we are also feeling like they've satisfied what the legislature set out here, and we are, taking that as our notification of. That doesn't really tell us anything of what they've done. But if that person, after they've checked that box, was later found to be in possession of firearms or ammunition, then it could be the crime of unlawful possession of a firearm. So it's just too new. This just all took effect on January 1, and so it's kind of too new to know how it's going to work out. We've already filed not that many contempts, but I'd say a handful of contempts for people who didn't follow the statute. Sometimes what we're finding is when we send them a letter saying we've charged you with contempt, then they are complying. They're turning in their forms, they're doing whatever. Those cases are getting dismissed when they comply before their first court appearance. It'll be interesting to see, I guess, a year from now, I'll be able to tell you how many contempt charges we actually filed on this, how many unlawful possession of weapon charges we filed. It really created a pretty convoluted system for us to follow and try to abide by, so we'll see how that all works out.